We're working out a little technical difficulties. My name is Alex Tishenko. I'm the articles editor for the Stanford Law and Policy Review. I'm also a public interest fellow at the Levin Center for Public Service and Public Interest Law. And I just want to welcome everybody to our conference this morning, Redistricting, Redrawing the Maps, Redistricting and Representation in the Next Decade. The symposium will feature top scholars and practitioners, some of whom whose work will be published in volume 23 of the Stanford Law and Policy Review. So we'll kick it off in just a second with an introduction to the law and regulation of redistricting, panel designed to bring everybody up to speed on some of the major background issues driving redistricting controversies. And then we'll move on to the more topical panels and the keynote. But first, I'd like to introduce Larry Kramer, the Richard E. Lang Professor of Law and Dean of the Stanford Law School, to offer opening remarks. Among his many achievements as dean, he's been a leader in fostering a multidisciplinary approach to legal scholarship and enlarging the clinical program, and in revamping programs that foster a public service ethos. And not to put any pressure on it, but in addition to his duties as dean, he's a leading scholar on constitutional issues. His most recent book, The People Themselves, Popular Constitutionalism and Judicial Review, grapples with some of the same issues of democratic representation and separation of powers that we'll be considering today in the context of redistricting. So without further ado,
As he started, I hate that bio. I have to rewrite that. The most recent book, actually that was 8 years ago now, since after I became dean. I just want to take a second to say welcome to all of you, and I want to offer some thank yous to some people who otherwise might not get thanked. I have notes just to make sure I get this right. So first, special thanks to Pam Carlin and to Diane Chin, who's over there, who have served as advisors to the whole conference in helping to identify some of the authors whose articles will be published and the speakers that you'll see today. Equally important, of course, Alex and Maggie Brennan. Where's Maggie? There you are, Maggie Brennan, as well as actually the rest of the Slipper staff. I suppose I should say that people on TV won't know what that is. The Stanford Law and Policy Review staff for all their work in soliciting the authors, editing the papers, organizing the logistics of the symposium, and putting this all together. Thanks as well to the staff of the Brennan Center. I'm thinking redistricting. The staff of the Levin Center, including Anna Wang, Nagar Katire, and Katie McKeon, who supported all of the programming and again the coordination and logistics of the conference, and also to Titi Liu, I'm really bad early in the morning, who donated her time to supporting the symposium after she arrived here pretty recently. And finally, to the journal members and the public interest fellows who did all the volunteer work and have basically worked on everything from picking up speakers, manning the registration desk, picking up coffee, all the really important things. And of course to all of you for coming. It's wonderful to see so many people here so early in the morning, so that's great. I'm really delighted with this particular conference, which of course is timely. The court has cooperated with us in making this an important issue, but in truth it's always an important issue. As Alex mentioned in the introduction, sort of thinking about what it is that makes democracy work has been a part of my scholarly work for much or most of my career, and there's a set of institutions that are necessary in order to make democratic politics possible, and they include things like political parties and the media, ways of financing campaigns, ways of selecting people to run for office, and so on. But redistricting is obviously critically important, and the way it's done, whether well or badly, has a profound impact on the entire process. So there are a few issues that are of more importance than that in understanding, from some perspectives, what's going wrong today, but from any perspective, what's happening today. The panels you'll see today and the articles that will be published in the next edition of the Law and Policy Review touch on three of the most important topics that will be shaping districting fights over the next decade. First, the changing demographics of the American electorate. Second, the continued application of the Voting Rights Act and its impact on redistricting controversies. And finally, there'll be a panel on the promises and pitfalls of redistricting reform, which we will hopefully see some of. But we're going to start the day, just to make sure everybody's sort of on the same page and brought up to speed, with a panel that is essentially an introduction to legal regulation of the redistricting process, and that will be led by Professors Pam Carlin and Nate Pursley. So let me just briefly introduce them for you. So Pam, most of you probably already know here, but for those who don't, is currently the Kenneth and Harl Montgomery Professor and also co-director of the Supreme Court Clinic here. I'm not going to go through her whole bio, but Pam is in some sense a real rarity in the academy in the sense that she is both a leading scholar, really well known and respected for her academic work, and also at the same time a leading lawyer and practitioner who's equally known for the work that she has done inside the courtroom. She has at least 3 leading case books in different fields, scores of influential articles and books, multiple arguments in the Supreme Court and in lower courts, and most important for today, is really one of the creators of this field of law as a recognized field of law. I mean, it's interesting, when I graduated from law school and went into teaching, people wouldn't have thought of election law, or as actually they named it, the law of democracy, as a distinct field of law. And Pam was one of a small handful of people who really drew together a lot of things, showed how they were interrelated, and how we could think of them as a field of law, and has been one of the leading figures then right from the start. So there's very few people in a better position to talk about the topic. One person who is in the same league, of course, is Nate Pursley. Nate is currently the Charles Beekman Professor of Law and Political Science at Columbia. Nate, if Nate can't share the title as one of the creators of this field, it's mostly because he came along a couple of years later. But since he went into teaching, after having graduated from here, I should say, since he went into teaching in 2001, he has been one of the leading figures. He has a PhD in political science as well as a JD in law, and redistricting has been one of his areas of special expertise, which has included not just academic work in the area, but also serving as both lawyer and special master in numerous redistricting conflicts and fights around the country. So with that, let me turn it over to them and enjoy the conference. Thank you all for coming and have a great day.
Well, thank you all so much for coming, and I want to echo Larry's thanks to the folks in the Levin Center and the folks on the Law and Policy Review, and especially to those of you in the audience. I first met Nate Pursley 15 years ago, about, what would you say, about 5 yards from here, but straight down, when he was a student in the course I taught on regulation of the political process. And the next fall, he organized, I think, probably the first voting rights symposium here at Stanford. And I wrote an article for it about the upcoming then millennial redistricting called The Fire Next Time. In that article, I compared redistricting to another important fundamental human activity. I wrote that redistricting, like reproduction, combines lofty goals, deep passions about identity, instincts for self-preservation, an increasing reliance on technology, and often a need, in Justice Souter's words, to pull and haul rather indelicately at the end. And of course, most of the time it also involves somebody getting screwed. That was before the millennial redistricting. We're now in the middle of the next cycle. And to quote what many of you know as one of my favorite poems, Alfred Tennyson's Ulysses, though much is taken, much abides. And though we are not now that strength which in old days moved earth and heaven, that which we are, we are. And so part of our topic today is going to be, who are we and why are we here, to quote Admiral Stockdale. Our format will be that we're going to set up the rest of the day by identifying and briefly talking about, in an interactive conversation, the various law that governs redistricting. There are, I think, 9 potential constraints, and they fall into 3 overarching categories. There are federal constitutional constraints on how redistricting can be done. There are federal statutory constraints on how redistricting can be done. And there are state law constraints. I'm just going to list them very briefly for you, and then we're going to talk about them during this panel to give you a little bit of a sense of where the law is now and where we think some of the major questions are going to be this coming time around. So the federal constitutional constraints begin with one person, one vote. They involve the question under the Equal Protection Clause of no excessive political gerrymandering, no purposeful discrimination against minority voters, and then in a kind of Goldilocks way, no subordinating traditional redistricting principles to racial considerations. So you can't take race into account too much in either of two directions. The federal statutory constraints are one that very seldom gets talked about, but the requirement initiated first in 1842 that federal congressional elections be conducted from single-member districts. Section 2 of the Voting Rights Act, which in addition to forbidding purposeful racial discrimination, also forbids the use of plans that result in minority voters not being given an equal opportunity to participate and elect candidates of their choice. And Section 5 of the Voting Rights Act, which, in addition to prohibiting purposeful racial discrimination, also provides that a plan cannot reduce minority voting strength relative to the pre-existing plan. And then there are state law constraints. There are substantive ones, and these vary from state to state. So, for example, in some states, there are definitions of compactness and requirements about districts being compact. In other states, there are things like so-called whole county provisions that require that redistricting try and keep certain political subdivisions in line. And then on top of these substantive constraints, there are a variety of procedural rules in different states for how redistricting should be accomplished. And so with that very broad overview, we're now going to go through these nine different kinds of constraints on the redistricting process to talk about where we might see some important movement in this coming decade and what some of the issues are. So Nate, I think maybe we'll start off with one person, one vote. Here there are two rules. One of the nice things about the Constitution, for those of you who spend a lot of time looking at the text of the Constitution, is you can look at the text of the Constitution forever and you're not going to find the words one person, one vote there. But you are going to find two different provisions whose words don't overlap at all that the Supreme Court has held both mean one person, one vote. So Article 1, Section 2 of the Constitution says that the members of the House of Representatives shall be chosen by the people. And the Supreme Court has held that the words by the people means using one person, one vote, districts of equal size. Similarly, the Supreme Court has held that the Equal Protection Clause with regard to state and local elections requires the use of one person, one vote. And so where are we now on one person, one vote, and what do you think is potentially changing?
Let me also thank the folks from Slipper, which was at least what it was called when I was here. And I should say that during my first year, I was the editor on Slipper. So not only was I a camp student.
This is a cautionary tale of where you might end up.
Right. Be careful if you're watching more. And so now, like many people in this room, I've been for the last year obsessing about the redistricting process. One of the great things about this field is that just when you think you're getting clarity, all you get is more chaos and ambiguity. One person, one vote is one of those areas. So the Supreme Court looks like it's about to entertain a case dealing with congressional districts. We had previously thought, or everyone's gone into this redistricting process thinking that you basically have to draw districts to be perfectly equal. They haven't said exactly that, but if you look at where most states have sort of behaved, you draw districts where the deviation is plus or minus one person. Right? Now, of course, the census isn't that accurate. It's all legal fiction. At most, you can say it's been a constraint on partisan gerrymandering, although not much of a constraint given what's been happening. But that was basically the math. But now in West Virginia, they have a case coming up that has a plus or minus deviation of about 0.5%. And it looks like the Supreme Court might sort of reconsider the precise rule of population equality that it has there, which is interesting because there's been a push in the other direction when it comes to state legislative districts. So in the last decade, we had this case out of Georgia, Larios versus Cox, where I did the remedial plan. In that case, there was a Democratic gerrymander that had overpopulated the Republican areas and underpopulated Democratic areas, and also had certain regional patterns to it. And the district court there, which was summarily affirmed by the Supreme Court, said, well, normally people think that you're allowed with state legislative districts to deviate. We're not going to require absolute population equality based on the textual argument that Pam mentioned, plus some other considerations. So you're allowed to deviate. You don't have to be so exact, but you can't deviate for these reasons, whether it's for overpopulating one party's supporters or favoring one part of the state at the expense of another. And so then it looked like you're going to have a more precise rule of population equality when it comes to state legislative districts, and a lot of state bodies this term have been behaving like that, trying to push down the deviations to much lower than they had been historically. Now, one of the funny things about the one person, one vote rule is that it's sort of a misnomer, because while the court says you have to have equality, it's not as clear as equality of what, right? And so while we all at the congressional level and state legislative level pretty much use aggregate population data, the total population, the total number of people being equal between districts, the court at least has one case where they say, well, you can use total registered voter population and break up districts according to that. But we all pretty much draw a district based on equal numbers of people. Now that's caused two issues this time around. One has to do with the prisoner population. And so New York, Delaware, and Maryland have all passed laws requiring the reallocation of prisoners to their pre-incarceration address. Because in New York, it has a pretty serious regional effect, because most of the prison population comes from New York City, and most of the prisons are upstate. And so that has a racially disparate impact, has a partisan impact, has a regional impact. And now there are challenges to those laws in the courts. So one thing with New York, the task force that's supposed to give us the data, we don't actually have the new data set that would be useful to draw districts based on that. But the prisoner issue is a live one for this cycle. And the other one, which is not really live, but is on the radar, has to do with citizens. And there's sort of I'll call it sort of frivolous case that was litigated in Texas, saying, well, you shouldn't be drawing districts on the basis of the total population. It should be on the basis of citizens, equal numbers of citizens. Now, we don't have the census. The short form of the census that we all get doesn't ask you whether you're a citizen or not, so that poses a little bit of a problem. But because we have paid attention to citizenship in other contexts, particularly Section 2 of the Voting Rights Act, there is this looming question out there as to how the interaction between what we call the denominator, one person, one vote case. State of Louisiana tried to petition for an original action in the Supreme Court, saying that the apportionment was unconstitutional based on the counting of non-citizens, but that wasn't appropriately so. But as I said, this is one area where the Supreme Court giveth and taketh away, and makes it for those of us who profit from flood on the highway in this area. We'll see what happens in the West Virginia case and see whether they're willing to roll that back. Here, why don't I introduce the next one, and I'll throw it to you.
Let me just say one thing before you do that, which is when in his autobiography, Chief Justice Warren, who was the author of Reynolds against Sims, the case that announced the one person, one vote requirement for state and local elections, said that he considered Reynolds against Sims, not, for example, Brown against Board of Education, the most important opinion that he wrote, because, as he said in his autobiography, henceforth this will ensure that the public interest and not special interests will be in charge of elections, which is one of those predictions that's right up there with Dewey beats Truman. False. But I think he thought, as Nate was just alluding to, that one person, one vote was going to be a real constraint on partisan hijacking of the political process.
So the constitutional claims with respect to race, both intentional racial vote dilution and so-called Shaw versus Reno claims, I think that the history here is sort of interesting, that one of the criticisms of the Shaw versus Reno line of cases, the use of race as the predominant factor in drawing the districts, was that it was going to be just open season each redistricting cycle. We were going to have an unending flow of claims. That didn't happen in the 2000 round, in part because people didn't say things during the 2000 round that they did say during the 1990s rounds, and also that people figured out ways to try to not make it look like race was the predominant factor in the districts, and the Supreme Court backed off from the alleged at the end of the 1990s redistricting cycle. Looking at this cycle, if anything, and correct me if you disagree with this, Pam, it seems like intentional racial discrimination claims are coming up and being more prevalent. And Shaw claims, I mean, you're getting some of them, I suppose, but none that are terribly prominent. But that we're sort of back to classic Mobile versus Bolden type fights that are coming out of different states.
I think that's right. I don't think there are going to be a lot of Shaw claims this time around, and I think part of the reason for that is the Supreme Court in 2001, in the kind of end of the review of North Carolina's post-1990 redistricting. And it is worth saying, you know, the 1990 census came out, North Carolina began its redistricting. The case went to the Supreme Court once early on partisan redistricting in a case called Pope against Blue, where the Supreme Court summarily affirmed the dismissal of the complaint. We'll talk in a moment more about partisan gerrymandering. It then went up to the Supreme Court as Shaw against Reno. It then went back to the Supreme Court again. It went back to the Supreme Court a third time. And finally, in April of 2001, just as the census numbers from the 2011 census were being handed to the states, the Supreme Court finally signed off on the 1990 round of redistricting. But the result of that is that most of the legislative districts that are being run for African American communities today are districts that were there already, and they're simply being preserved, and therefore you can always explain those districts as simply preservation of existing districts or protection of incumbents. And so Shaw claims, I think there are going to be very few Shaw claims involving majority black districts, except in areas where the black population is decreasing so much that you have to really struggle to continue to comply with one person, one vote and keep the districts in place. The other thing is, because of the political realignment, the places where Latino districts are being drawn, they are not generally being gerrymandered. What's generally happening is purposeful discrimination against Latino populations rather than attempts to draw districts where there really aren't enough Latino voters to effectively create a district. And so I think you're absolutely right that almost all of the intentional racial discrimination claims this time around are going to be claims by minority voters challenging existing districts or proposed districts rather than by non-minority voters claiming race played too much of a role in the process.
You know, something that the students often don't appreciate until they sit in front of a computer. One thing I should pump the website that my students and I have done, which is drawcongress.org, where we've done maps for the whole U.S.
It's not part of Hang and Quarter Congress.
Maybe we should have been craft Congress though. And it's not that hard to draw majority-minority districts, compact majority-minority districts much of the time, you know, and that a lot of what the disfigurement in those early days was the push of so many different considerations at once, like incumbency considerations, partisan considerations, so then you end up with some of these squiggly districts. It's also the case, which you're talking about the African-American districts, that not only because of incumbency, but because of other factors, that a lot of the more heavily packed districts that historically were necessary are not as necessary in a lot of these areas. And as you said, sometimes you just can't draw them. There are some, because of the relative decline of the black population in particular areas. When I say relative, meaning not keeping up with pace with particularly Latinos, but also in some areas whites, that then you just can't draw these majority African-American districts. There are still some out there. If you look at Corinne Brown's district in Florida, that's a sight to behold, and there are a few others here and there. But then you look at the white districts. The district I live in, the Harlem district, but the one just south of us, goes all the way from the Upper West Side of Manhattan, all the way down through Greenwich Village, jumps over the Brooklyn Bridge, goes into parts of it, gets Borough Park, Brooklyn, keeps going until it ends in Coney Island. right? Otherwise known as the Nathan's to Zabar's dispute, if you know where it's and so, you know, funny shapes happen all over the place, and they happen for many different reasons. And, you know, compactness is often, I've drawn districts where, like when I drew the plan for Georgia, I drew a nice square district in northern Georgia. It would be something that Justice O'Connor would really love. But it had a mountain range right in the middle, which meant that you had to go outside the district in order to get from one side to the next. And so shapes can be deceiving. But I see, yeah, in this redistricting cycle, particularly in Texas, but elsewhere, these claims of intentional racial discrimination are going on. So does Justice Kennedy get to decide that there's authentic partisan gerrymandering?
Yeah, so this is the thing about partisan gerrymandering. The last time the Supreme Court looked at the issue in depth was in a case called Vieth against Jubileer from the 2000 round of redistricting in Pennsylvania, where the Republicans were in control, and although the state lost, was losing, I think it was 3 seats, they managed to pair all Democrats and try to get some additional seats for the Republicans. Now they guessed a little bit wrong about this, mostly because some of their candidates got indicted at and so they didn't quite succeed in picking up as many seats as they had hoped for. But the Supreme Court split into 3 groups. 4 of the justices, led by Justice Scalia, thought that although political gerrymandering might well violate the Constitution, and therefore there isn't an argument, it's not as if any of the justices think excessive political gerrymandering is constitutionally acceptable, but 4 of the justices, led by Justice Scalia, thought that claims of political gerrymandering are not justiciable. That is, that the remedy for political gerrymandering is, to quote the wonderful line of Justice Frankfurter's, to sear the conscience of the people's representatives to persuade Congress to deal with the problem of excessive gerrymandering. You know, and I think it's unlikely that the people's representatives are capable of having their consciences seared in quite this way. But those 4 justices would have left the question of political gerrymandering and how to enforce the constitutional prohibitions entirely to the political process. By contrast, 4 other justices thought that political gerrymandering claims are justiciable and that there is a well-developed and manageable standard for resolving them, but they split 3 ways about what that well-developed and manageable standard might be. In the middle, no surprise to people who watch the court, is Justice Kennedy, who said, one has the feeling lines were crossed here. So he did not want to hold that political gerrymandering should never be justiciable. On the other hand, he said he had not yet seen a standard that would allow courts to step in and decide political gerrymandering claims. But he didn't want to rule out the possibility that there might be some standard that someone would come up with in the future. And so that means that people still have an incentive to file political gerrymandering cases in the hopes that they can come up with a standard that Justice Kennedy will find sufficient for judges to intervene and then to have been violated in their particular case.
Let me just add one thing, which is that he says, well, look in the First Amendment. Maybe that's where you can find some constraint to partisan gerrymandering, because, you know, political parties are associations, and so in the event it discriminates on the basis of
belief or something, yeah.
Which sort of reminds me of sort of bad law school exam answers, where students figure, if only I could find that part of the Constitution, you know, and I'll remedy this part, you know, of the ambiguity in the court's decisions. And so, if you have, you know, go look in the First Amendment and see if we can solve this problem of manageability of partisan gerrymanders, and then we'll get the attention of Justice Kennedy.
Yeah, so people have tried to come up with various quantitative measures on the theory that the Supreme Court found one person would vote a very tempting measure, sort of what Justice Stewart referred to as constitutional law's 6th grade arithmetic. They've tried to do some First Amendment-based arguments, but what really I think happens, and I think the Supreme Court does enforce some constraints on excessive partisanship, is they use other doctrinal hooks to get there. And so Nate alluded earlier to the Supreme Court's summary affirmance in Cox against Larios, in which the Supreme Court essentially said, although we have held in the past that population deviations of less than 10% are not a violation of one person, one vote, we're going to affirm a district court decision striking down a 9.9% population deviation on the grounds that The only thing that explained that was incumbent protection and partisanship, and those are illegitimate reasons for deviating. A number of the Supreme Court's voting rights cases, I think, can be explained in part as the Supreme Court using the Voting Rights Act as a tool for limiting the amount of partisan gerrymandering. Because, and this goes back to Nate's point about the Shaw cases, what really happened in the Shaw cases was the Supreme Court essentially saw districts that were very oddly shaped, not for primarily racially relevant reasons, but because the Democrats who were in control of the process at the time drew those districts with the intent of also moving a number of minority voters into the districts of white Democratic incumbents to serve as a kind of what I used to refer to as a kind of meal extender, a hamburger helper, because you don't have enough meat in your district, you have to get them from someplace else. And so there are constraints on political gerrymandering. The question is, what is the Supreme Court going to use as the constraints this time around? So I think that's pretty much it on the giving you a sense of the constitutional constraints. You can't take race into account too much to help minorities. You can't take race into account really at all to hurt minorities. You have to comply with one person, one vote in some particular form or the like. So let's turn to the statutory ones now. I think there's one we can kind of get off the table fairly quickly. And that is the requirement for congressional elections that elections be conducted from single-member districts. That is a purely statutory requirement. It's one of the things that separates the United States from most other advanced democracies, which elect their national legislatures, at least in part, through proportional systems. I think there is 0% chance of that changing in any way. And indeed, the one major effect I think that the single-member district have is it requires and puts a lot of pressure on courts to draw plans if legislatures can't. That is, you might think, and indeed in 1964 and 1966, I believe Alabama actually ran its primaries this way, that if you can't draw a new plan that complies with the Constitution and gets put into place in time, then all of your congressional districts are going to be elected at large. But because of this statute, courts don't do that. Courts will enjoin an existing plan because it violates one person, one vote, and if the state doesn't come back with a new plan, they'll draw a plan themselves for congressional districts. That's probably the major importance of that. You want to?
Section 5 of the Voting Rights Act. Let's talk about it while it's still around.
Oh, stop that, Nate. It will be around until 2027. When it will be renewed.
So there are, I think, 5 now constitutional challenges to Section 5, 4 or 5 of them going through the courts. We had a case.
You might want to say what Section 5 is.
Yeah, Section 5 of the Voting Rights Act applies to some parts of the country and not others based on various criteria, such as whether in 1964 these jurisdictions had literacy tests or some kind of test or device and had voter turnout below 50%. But it was reverse engineered to try and target areas where there had been discrimination against minorities from sort of 1964 through 1972. Parts of California are covered, but most of the areas that are covered in full, at least, are in the South. And so there's a series of cases going through the courts. One that went to the Supreme Court, affectionately called the Namudno case, or the MUD case, from the Municipal Utility District.
Northwest Austin Municipal Utility District #1, hence the MUD-No.
Came through, I guess 4 years ago. And the court cast some serious, showed its concern as to the constitutionality of that coverage formula for Section 5 of the Voting Rights Act. And so you have the state of Arizona challenging it now, you have cities in North Carolina, or some plaintiffs in North Carolina, Shelby County, Alabama, it's coming up in Florida, it's coming up in Texas, as to the constitutionality of Section 5. We'll see whether the court is willing to take that on. That would be a pretty major decision. I mean, they will take it on. The question is whether they're willing to use a scalpel or a cleaver, I think, in striking down Section 5. And that has sort of cast a shadow a little bit on this redistricting process that the Supreme Court is potentially going to rule Section 5 unconstitutional. Even in the most recent Texas case, they sort of reiterated their concerns about the constitutionality of Section 5. And at the same time that we have those cases that are hanging out there, we can talk more about them, we have a new standard for Section 5 of the Voting Rights Act, which was passed in 2006. And the Voting Rights Act reauthorization amendments of 2006 said that the Department of Justice, which is charged with reviewing voting laws by these jurisdictions, or the DC District Court when it reviews voting laws, must make sure that they don't have any discriminatory purpose and that they do not have any discriminatory effect, retrogressive effect, which is that they don't diminish the ability of minorities to elect their preferred candidates of choice. And so now the question facing the DC District Court in this Texas case, facing the Justice Department, for example, in their pre-clearance denial of the voter ID law in South Carolina, is, well, what types of redistricting claims are making minorities worse off, diminishing the ability of minority groups to elect their preferred candidates of choice. Those words that were inserted in the statute were overturning an earlier court case, Georgia versus Ashcroft, that said jurisdictions were allowed to trade off districts that would elect the minority preferred candidates against those where minorities might have some influence over the election. And so by moving toward the ability to elect, the standard tries to bring back what pre-existed this Supreme Court decision. The long and the short of it is, there's a lot of, I won't say controversy, but there's a lot of disagreement among partisans as to what that standard means and how DOJ is behaving. One of the interesting things, DOJ has actually not interposed an objection for a denial of preclearance to a redistricting plan, except in two very small cases, one dealing with East Feliciano Parish in Louisiana and Amity County, Mississippi. They are participating, of course, in the Texas redistricting litigation, which is going on in DC, and so we get a sense of how they interpret this provisions from that. And there's several states that have opted not to go the DOJ route this time around and are going instead and litigating these Section 5 voting rights cases in the DC District Court, which then may lead to Supreme Court review. We have besides those three examples, South Carolina and those two redistricting cases, there's also this case out of the city of Kinston, North Carolina, which is challenging the constitutionality of Section 5, where the Department of Justice denied preclearance from a move to nonpartisan elections there. So I think those three objections, or four objections, which include South Carolina plus Texas, are the only two indications as to what this new Section 5 means. And a lot of these cases, Texas is an example of it, as well as those two redistricting situations I mentioned, they make the argument that there's a discriminatory purpose that is underlying these voting laws of these redistricting conversations.
Yeah, so I think there's, obviously the question of the constitutionality of Section 5 will get back to the Supreme Court sometime in the next term or so at the very latest. In the meantime, it's clear that Section 5 has been working. That is, there has been very little retrogression. And the places where there has been retrogression, either DOJ has objected or in the Texas case they're litigating the retrogressive nature of the congressional and state legislative plans. This is one of the things I think is difficult to get a true handle on, which is how do you know that a statute that's designed to deter or prevent something is working? And so people oftentimes say, well, DOJ isn't objecting very much. That's a sign that the Voting Rights Act isn't needed. But of course, that's a little bit like saying, we have a law against murder. We don't need it anymore because very few people are being killed. It may well be that the presence of the law is the thing that deters or prevents the behavior. Moreover, the Voting Rights Act, I think, now has become so institutionalized, and Section 5 review has become so institutionalized in a lot of places that it takes jurisdictions off the hook of having to have tough conversations because they simply said, well, DOJ will never pre-clear this if we do it this way. So instead of talking about you know, it would be the wrong thing to do. They just say DOJ won't be clear, therefore we can't do this. And it provides a lot of political cover to jurisdictions to simply do what I think is the right thing. I agree with Nate that the real question, I think, when Section 5 goes back to the Supreme Court is not going to be up or down, is the whole thing unconstitutional, because I think it not super likely that the Supreme Court wants to issue the kind of opinion that will lead to popular press coverage that says Supreme Court strikes down crown crown jewel of second Reconstruction. So on the Supreme Court now, I think what you tend to see is narrowing constructions of the Act, hence Congress's attempt in the 2006 Act to override the Supreme Court's decision in Bossier Parish about what discriminatory purpose means, and to override the Supreme Court's decision in Georgia against Ashcroft. And so you do get that kind of back and forth. And I think the Mudno is a perfect example of that, where the court invented a larger bailout provision than Congress would have provided. But I'm not sure that there really is a consensus on the Supreme Court that the Voting Rights Act is unnecessary. And indeed, the decision of people who are losing purpose-based objections, to take those up as the constitutional objections is a very bad tactic on the part of foes of the Voting Rights Act, because the ideal case for foes of the Voting Rights Act to take up would be a totally blameless jurisdiction saying we don't understand why we have to do this. And I think they tried to do that in the Mudno, but it was a little premature. Instead, they have Shelby County, Alabama, which is part of a state that has had a series of statewide objections, and a county in which there have been objections to what subdivisions have done. They have Texas, which the Supreme Court just saw, I think, pretty powerful evidence of purposeful racial discrimination. And that's a very bad tactic if you want to say a law is no longer necessary, to have people who are really the best kind of targets of law going up there and saying, look over there, there's somebody blameless out there. So it'll be interesting to see where that goes.
I'll say one other thing, which is that I think in many ways the Voting Rights Act may be the best, the greatest beneficiary of the Citizens United decision. The blowback from Citizens United may make the court a little bit more timid to come with a meat cleaver to the Voting Rights Act in the short term. You know, that you'll get some narrowing constructions. I think for sure, if this case out of the city of Kinston goes to the Supreme Court, they'll find some way to say that that was the DOJ objection there was wrong. But you can do that in any number of ways by trying to sort of limit what the statutory language that repairs Georgia versus Ashcroft, what that means. So should we move to Section 2? So Section 2 of the Voting Rights Act, which prevents against racial vote dilution everywhere in the country, not just in covered jurisdictions. There was some action over the last decade in Section 2, two major cases, though there's more than that. Bartlett versus Strickland and Lulak versus Perry. In general, the standard under Section 2 was that if you are a large and compact minority community and you are in an area with histories of discrimination and particularly present conditions of racially polarized voting, that you were going to be entitled to a majority-minority district. Bartlett versus Strickland says, yes, when we said majority, we meant majority, so it has to be over 50%. Unfortunately, they didn't say over 50% of what? It's that denominator question that I said before. Citizen voting age population, voting age population, 5th Circuit and 9th Circuit, I guess 11th Circuit. Basically, a lot of the circuits where you might care about the citizenship issue are all saying, yeah, you've got to look at citizen voting age population, which causes some real interesting challenges since we don't have the same citizenship data at the, you don't have it on the census forms, you have to use survey data. But so Bartlett says it's over 50%. It leaves open two issues. The first is that one about the denominator. The other is about minority coalition districts. So can you group together African Americans and Hispanics, for example, in particular areas, in order to surmount that 50% threshold? The recent Texas decision has a cryptic sentence in it which kind of suggests, well, maybe not, saying that the district court's decision in Texas, if it thought that you could do that, they might not have really understood what Section 2 is about, but there's, if they wanted to be clear, they could have been, and they weren't in that case. On LULAC versus Perry.
I think, just to say something about that and Bartlett against Strickland, the Supreme Court was so focused on the word coalitional that they didn't focus on coalition of what. That is, in Bartlett against Strickland, the claim was a coalition between black and white voters would be a effective voting majority in the district. In the Texas case, it was a coalition between black and Latino voters. And I think the Supreme Court didn't focus quite as much on that as they might have in trying to figure out whether minority coalition districts are something people can bring a claim on, because that's something that in areas where there are large cohesive minority communities made up of more than one racial or ethnic minority, people have been bringing claims since the 1980s, as opposed to the Bartlett against Strickland style claim, which was really much more of a kind of post-2000 sort of claim.
Particularly confusing because Justice Kennedy decides to rename all the claims in Bartlett versus Strickland, rename districts. So what we thought were coalitional districts are now crossover districts, and then you have minority coalition districts, and so they confused us and they confused themselves. So if that's what underlying Texas, I see where they're coming from. LULAC versus Perry, which Nina Perales litigated, so we should give credit where it's due in that. This is the rare Section 2 victory at the Supreme Court, where the Supreme Court says that the dilution of the Latino vote in South Texas by shaving off a district which was on the verge of electing a Latino candidate of choice, you cannot compensate for that shaving off of a district by drawing a district that stretches from the Mexico border all the way to Austin, which is a culturally very diverse district, and that the Latino populations there did not have an entitlement to a district under Section 2 of the Voting Rights Act. Really, this case, the way I read it, is that there's Justice Kennedy still believes a little bit in Shaw versus Reno, and so now he's trying to merge it into his concerns under Section 2 of the Voting Rights Act. But part of the interesting inquiry that then comes out of this is, well, is it not just geographically compact minorities that have claims and entitlements under Section 2, but how culturally similar do they have to be? You have to sort of add something to this notion of compactness.
And I think the question in Section 2 cases, in addition to geographical issues and the like, is going to be how we think about racial bloc voting. Justice Kennedy is very much an individualist as opposed to a group-oriented justice. And I think part of what upset him so much in LULAC against Perry was the idea that you had a really quite vibrant, politically organized Mexican-American community on the verge of electing a congressman, and they were told, you don't get anything, and here, we'll just defend this entire plan by drawing a district someplace else. I'm not sure, even if that other district had been okay, that Justice Kennedy would have upheld Congressional District 23, because I think he was offended by what he saw as purposeful discrimination. And this goes back to one of the things that the Voting Rights Act allows you to do, which is it allows courts to strike down plans that they believe to be unfair without calling anybody an outright racist. Whereas the Constitution requires, after Washington against Davis, that you hold that some person acted with discriminatory purpose. And so the Voting Rights Act allowed him, without saying, you know, the legislature of Texas were a bunch of racists here, to say this district wasn't fair. So that issue's still in there, but the other issue is how you measure racial bloc voting, what counts as sufficiently significant racial bloc voting. As we move, and over the past 50 years this has become increasingly clear, as we move into a world in which partisan affiliation and racial identity or ethnic identity are much more closely linked in some important ways. In the South, the question of how you decide, is this racial discrimination or is this political discrimination, comes up again. That is, you know, the state of Texas often claims in these cases that they aren't screwing over Latinos because they're Latinos, they're screwing them over because they're Democrats. And they are perfectly happy to have Latino Republicans elected. Therefore, how can you say that this is racial discrimination? Well, that raises important issues that I think the Supreme Court is going to confront. They've confronted them several times already in just, is racial bloc voting simply about correlation, Or you have to show some level of causation in which we're now inquiring into the motives of individual voters. And so that, I think, is a set of issues that could end up back in the courts this time around.
I'll say one thing about Bartlett and how it's relevant to that. So in Justice Kennedy's opinion in Bartlett versus Strickland, he has this dictum suggesting that, well, 25% white crossover voting might be enough to immunize a Section 2 claim. And most people thought that that was a low enough level of white crossover voting that it would probably a Section 2 claim would still be viable. But because you're frequently going to be able to get 25% crossover in certain areas. But a lot of it, in my experience, is you really can't even look at states as a whole. That there's such the areas of racial polarization. There'll be places where you can have a 40% minority district, African American district, say, which will perform for the African American community, and then other places where you need to get well over 50% in order for it to be a performing district.
The interesting thing about what courts look at and see as significant crossover voting is if I were to tell you that in a particular election one candidate won 75-25, no one would say a significant number of voters voted for the losing candidate. Right? When we talk about landslides in the United States, usually we're talking about 60-40, right? You know, if we ask like Reagan's landslide, what did he get? 61% of the vote, 58% of the vote? That's usually what we think of as a landslide. And so when the courts start talking about, well, having 25% of the white voters willing to vote for a minority community's candidate of choice is a lot of people. It's a lot relative to zero, but it's not a lot relative to what we normally think of as significant attraction of votes. So
all right,
now
state law.
State law ones, yeah.
That's where things get really interesting, I think. Well, it's all been interesting up till now, right?
But now they're about to get fascinating.
Yeah.
Galvanizing.
Well, just because there's such, you have similar provisions in different states, which mean completely different things depending on the Supreme Courts of those states and how they interpret things like compactness or the political subdivision requirement. I drew a remedial plan for Maryland after they struck down the state's plan because it didn't show due regard for political subdivision lines. Whereas some states have much more rigid pronouncements about obeying county and city lines, and they sort of get a pass. And so different states, and we have, I think this, I was just counting, Missouri, Pennsylvania, and Idaho have all had courts that have struck down the plans on political subdivision grounds this just in the last month. And then you have some of these other criteria. Arizona, which has a commission, has a requirement that some of the districts be competitive. Right? They were in litigation for 6 years in the 2000 round because of that. Others have, certain types of community of interest criteria, and a lot of it, if you're aggrieved by the redistricting plan for partisan reasons or otherwise, well, you throw all that at the wall and see what sticks. And there's been some success in these state courts on those different grounds.
Yeah, and of course, a lot of the state courts themselves are elected in partisan elections, and so they are perhaps more closely tied to the political process than the federal courts. And that's one of the other things that we haven't mentioned yet that's worth mentioning is, in addition to all of the substantive rules, the major effect that one person, one vote has is the minute the census numbers drop, all of the districts in the country become unconstitutional. And that means somebody can race into court immediately. And I think one thing that has been resolved is the Supreme Court has held that if state courts and federal courts both have cases in front of them, the federal courts are supposed to wait until the state courts have adjudicated the state claims before they step in and adjudicate the federal claims on top of that, leaving aside Section 5 for the moment, which is an immediate injunction. And so I would predict that, especially when it comes to a lot of local elections, you're going to see people going into state courts rather than into federal court, even on plans that could have been challenged on federal court grounds on the assumption that that will give them 2 bites at the apple.
Yeah, I think that I'm trying to think what's happening now around the country. I should say 34 states now are in litigation over one or another redistricting plan.
And that's low.
Well, it's still not over.
Everybody
Still time.
doesn't still have a plan.
New York, when I did I was working for the federal court drawing a plan 10 years ago, and there were simultaneous proceedings in the state court. And I'll say, this is being paid, but what the hell. you know, they took basically the plan we drew and then, you know, did the little tweaks here and there. You should see what they built this day for that. But it was, you know, you often will have simultaneous proceedings in state and federal court, but with the abstention doctrines that Pam's talking about, you'll get the federal courts that'll wait. But a lot of what happens in the race to the courthouse is, you know, people think that they're going to get a favorable forum in one as opposed to another.
And then the last group of kind of constraints on states are not so much what the districts are supposed to look like, but how you're supposed to get there. And here, I think one of the major shifts from 1964, which is really when the reapportionment revolution got its steam up, and today, is the number of states that have gone to or are thinking about going to some form of redistricting other than having the politicians draw their own districts. For many years, we've been saying that, you know, the kind of public face of democracy in the United States is every 2 years people go into the voting booth to select their representatives, but the private face is every 10 years the representatives went into back rooms and selected their voters. That has changed in some states because they have moved to independent redistricting commissions, but the variety here, to go back to the point Nate was making earlier, the variation in how those commissions are set up, how they're selected, what happens to their plans is kind of staggering. So that some of the commissions have been really quite successful, and others of them, it's hard to think of any difference in the outcomes that from what would have happened if it had been a purely political process.
And you know, one commission during one redistricting cycle will behave differently than the other and face different types of criticisms. That's what we're seeing in Arizona. We'll talk more about this on the panel I'm moderating later in the day. But Arizona, which was held out to be the, even though it was in litigation for 6 years, at least a nonpartisan enterprise at the beginning of the 2000 round, then found itself in this maelstrom of political controversy where they impeached the independent head of the commission, then reinstated by the Supreme Court. I want to, unless we have more legal things, I want to just, and I'm going to put on my political scientist hat just for 2 minutes. I know we're over time, but just talk. Oh, we're not to give just a sense of just the large themes that I see in this redistricting cycle. You can think about them sort of race, party, and region, and that while we've talked about the particular legal claims, a lot of, you know, redistricting can be a window on demographic change in the United States that sort of we take account every 10 years. We do it with the census, but this is in many ways the time when we really get a sense of changing political geography. So if there's a theme this redistricting cycle, I think it's the meteoric rise in the Latino population, and you see it obviously in controversies in Texas and elsewhere. Also, it's people tend to think about it in classic areas like Texas and California, maybe Florida, but it's really throughout, not just the South, but in northern cities as well, where I live, in Harlem, which has historically been seen as a majority black area. It's now plurality Latino, and so the Harlem district is plurality Latino. And so there's a similar theme there, which is that the African American population has not been as keeping up with pace, and so that it becomes a little more challenging to draw some of these districts as we talked about before, but also not as necessary because of success of certain African American incumbents and others in getting crossover voters. The relevance of the Obama election, I think, is in the background of a lot of discussion of these issues, even though it doesn't really come up in court. I'll be interested to see if it does lead the Supreme Court to think about Section 5 in one way or another. But even though, you know, the presidential election might be one of the most irrelevant pieces of information if you're trying to figure out racial polarization in a school district election, I think that there's some sort of cast to the way a lot of people think about the Voting Rights Act based on that. And as a bridge between thinking about race and party, it was often thought, as Pam was describing in the 1990s, that the Voting Rights Act and restrictions on minority vote dilution was a hindrance to Democratic Party gerrymandering. I think now in this cycle, we're seeing the Voting Rights Act being a constraint on Republicans maximizing beyond what they got in the 2010 elections. So you see that in Texas, you see that in Louisiana, area which is very interesting given the demographic changes because of Katrina, where in many ways the one majority African American district that's there in New Orleans is one that if you were really being a partisan gerrymander, it would have been one you might have split up. And so as a result, that district is safe under the VRA. With respect to party, Republicans have more state legislative seats than at any time since 1928. They also have total control of the redistricting process in twice as many states as they did in the 2000 round, and particularly in a lot of the battleground states. And so a lot of that has meant that this high watermark of Republican dominance is then transferred into them trying to protect their incumbents in much of the country, whereas in the 2000 round, a lot of it was trying to extend their advantages. They certainly have tried to do that again in Texas, but if you had to sort of look at what was happening and a difference between 2000 and 2010, it's trying to preserve the gains of the 2010 race. Now, last on party, I think in talking about commissions, it's clear, I think, given the criticisms of both California and Arizona, that Republicans now believe commissions are not in their interest. It wasn't always that way. It wasn't always thought that nonpartisan redistricting would have that kind of effect, but it seems pretty clear to me that they believe that as an institutional form, they have more to lose. Now, a lot of that is because they control so many state legislative houses, so anything taking redistricting away from those state legislatures might be seen as against their interests. Finally, just regionally, the shift of congressional seats from the Northeast and the Midwest to the South and Southwest obviously has a huge effect on congressional districting, so that Texas had 4 more districts to play with. A lot of the Sun Belt does as well. But as we've been describing the issues that are coming up this time, demographic shifts, with Louisiana losing a congressional district as a result of Katrina, all of the interesting cases that happen are occurring in Texas. We have, as mentioned before, the Arizona chaos to study in the coming years. Florida, which we haven't even talked about, has its own new initiative that says that the state plan may not intentionally favor or disfavor an incumbent or political party. And so just this week, the Florida legislature has proposed their maps, and they'll go to the Supreme Court next week. It has to be approved, I think, by the following week or something like that. So this it feels like we're in the middle of this redistricting cycle, but one thing, those of us in this field seem to, what might have been a once-a-decade phenomenon now is about 3 to 4 years per decade, I guess, given the litigation that results from it. So we're just at the beginning of it.
Yeah, and this panel is obviously called Introduction to Redistricting in the 2010's, What's at Stake. And so far we've been talking about what's at stake internal to the process, which is what will the Section 5 rules be, what will the political gerrymandering rules be like. But I think it's worth kind of ending our remarks, and we'll have a little bit of time for questions from the floor here, on what's at stake is, of course, who controls the legislatures determines the nature of policy in the succeeding decade. And so one of the things that elections are supposed to do is to enable a kind of nimbleness in response to changes that people see in their situation. But if you have the kind of redistricting that we often have in the United States, once the districts are set in stone, it's predictable who's going to win those districts for the next 10 years. You can predict that without knowing anything about who the candidates are going to be or about what the issues are going to be and the like. And so I think there's a lot at stake in how the districts are drawn beyond the interests of the particular candidates in a particular round of elections. And it's worthwhile, I think, to remember that as we talk about what sorts of constraints there should be. We have time for questions and comments, and please keep those short and come to one of the microphones or have one of the microphones brought to you. And just a reminder for everybody, you are being taped, so by talking, you're consenting to being taped.
Our enemies will know.
So please give your name, home address, and social security number.
My name is Ken Agel. I live in Portola Valley, nearby for those in this area. My question is about the concept of race. Is it a legitimate situational concept in the sense that race is a predictor of social disadvantage. And if that's the case, then the concept of race in 50 years may be no longer important as a determinant of voting policy. So, general questions about the concept of race as a factor and its future.
So there are a couple of different answers to that question. One is, how is race thought of in the political process? And there I think the starting point is constitutionally race is treated differently from some other criteria. That is, the 15th Amendment to the Constitution prohibits discrimination on the basis of race or color in voting. And the 14th Amendment has been interpreted, although it doesn't use the word race, to contain additional prohibitions. Now, the Voting Rights Act itself uses the term race without defining it, but also contains protections for what are referred to by the Act as language minorities. And this is Asian Americans, Spanish surnamed Americans, which is a little bit of a misnomer, Alaskan Natives, and Native Americans, that is American Indians. And these groups are protected not by the Act explicitly as members of racial groups, but as members of language minority groups. I think because Congress was struggling to come up with a way of explaining who it was trying to reach and protect. I don't think this is mostly about social disadvantage as much as the historical political disadvantage. That is, people were identified by the state as members of racial groups, and then the state actually diminished their political participation. I've written that when it comes to Section 2 cases, if race no longer has an important meaning in people's lives, if 50 years from now we reach that kind of assimilationist nirvana in which if you asked somebody to describe somebody else, their race would never come up, then the Voting Rights Act will have nothing to say about race, because at that point there won't be racially polarized voting, and there won't be restrictions on people's ability to elect preferred candidates because of race. Just as, for example, right now, left-handedness versus right-handedness plays no role in the political process. There isn't polarized voting along those lines. People don't have distinctive needs that they feel the political process ought to be responding to. So in the long run, if race stops meaning what it has meant in American history for the last 400 years, the Voting Rights Act will kind of, I hate to ever quote Karl Marx, especially on television, but like the withering of the state that traditional Marx talked about, there'll be a withering of the Voting Rights Act because it will no longer have any meaning. It will be on the books, but it will be, it won't play any operative role.
I would add just one thing to that, which is it varies between different groups. How we measure race and how you identify populations, so that in the 2000 census, for the first time, individuals were allowed to check off more than one race on the census form.
Yeah, that's part of it.
And the for some groups, then the variance, which is that, you know, the maximizing categorization and the minimizing categorization makes a big difference. So Native Americans, right, depending on how you count people who merely check off Native American alone, or those plus some other race, the numbers will increase by over a third. Right? Asians in some parts of the country, you will get Sacramento actually is the area that has a very high rate of Asian multiracial identification, so it really makes a difference. With African Americans, it's not, you don't see much of a shift. You get some small differences, but doesn't, you just don't have identification that is as broadly multiracial as it with some of the other groups. The area where you do get some of that is in New York. It's very interesting looking at different groups and how they define themselves, African American groups, or I should say black groups, and how they define themselves and levels of multiraciality. And so Ken Pruitt, who was the director of the 2000 census, has a book that's coming out on this question. Because his feeling is, outside the redistricting realm, that pay attention to the census and the racial categories and see how that will alter people's conceptualizations. But with respect to redistricting and the Voting Rights Act, the real question is, yeah, if there's no difference in voting behavior, then there's no claim, right? And so then we don't even need to account for it.
My name is Jeff Schwartz. I live in Saratoga. My key computer passwords are. Could you comment generally on the interaction in challenges, if there have been some, of district determination and the primary process, and particularly here in California approaching the first open primary, where it would seem that that might either add to or undo some of the court-imposed restrictions and some of the statutory restrictions in the Voting Rights Act.
I'm positive I get that. I mean, I think that so there's a lot of ways to talk about that topic. Depending on whether you have a closed or an open primary, it is sometimes the case that certain groups, racial groups also, will be do better under one type of primary system or another. This is actually the issue in that Kinston case, that North Carolina case, where the Department of Justice said that the move to nonpartisan elections makes it less likely for minority African Americans to elect their preferred candidate of choice, and so they denied it under the Voting Rights Act. So that's an interesting area where that's happening. A lot of what I'll tell you some research that I've done on that case in North Carolina, which is that depending on whether there are parties on the ballot and depending on whether it's a partisan primary, it will affect turnout among different groups, so that if you don't know if someone's a Democrat or a Republican, there are groups that will not vote in that election. So there's a racially disparate impact, not just in voter turnout, but also in what we call roll-off, the likelihood that they will actually vote for nonpartisan races as they go down the ballot. But on the general question of kind of the interaction between race and party, depending on the primary system, it really sort of depends. There are different areas. We look at Louisiana, where it was often thought that the nonpartisan primary, the open primary, well, similar to what you're going to have here, but the fact that they had basically a runoff from a general election was thought that advantaged David Duke when he was trying to run for office. But I think that there are a lot of variables that you have to sort of look at in these things. It's hard to tease them out.
And the other thing that I think is going on is people's frustration with the districting system often leads them to try to tinker with how primaries are done. I think that's part of the motivation in California is if you have districts that are drawn largely to create safe seats, what those districts tend to be is overwhelmingly one party controls the district. So the general election is kind of meaningless because whoever gets nominated in the dominant party's primary controls how that election will come in. The result of that is people who don't like that try to say, okay, well, is there anything we could do to create more moderate representatives? That was the kind of impetus between Tom Campbell's first attempt at the kind of open primary and the like. And this is something worth kind of thinking about more generally, which is that the entire system is an ecosystem in which each of the pieces affects other pieces. That is, why has there been such a push for term limits in almost every state that has initiatives? There are term limits on legislators now, in part because people thought, well, we can't vote them out of office because they draw the districts in a way that makes it impossible to vote them out of office. So the only way we can get them out of office is to put term limits in. If the Supreme Court, as they have, has made it impossible to have meaningful campaign finance reform in a variety of ways, well, that pushes money into the process in ways that leads people then to say, we have to do something about incumbents because otherwise they can raise this money. So part of, I think, what you're talking about in your question is what effects on the districting process do things like open primaries have in which people, or top two primaries, or blanket primaries, or like, they change the salience of the political party label in the more meaningful election. We don't know exactly how yet, and it will vary from place to place. They change, as Nate says, the turnout. They may change who gets nominated in these seats that are safe for one political party rather than another, and they may change voters' sense of their own party identification.
And I mean, just to get at what I think the sort of political strategic issue often is here, which is, depending on the primary system, do you have to create districts of a certain level of minority concentration for minorities to elect their preferred candidate of choice? So, for example, if if you have a nonpartisan election where basically the top two candidates then advance to the general election, is it the case that you need to have over 50% African American for that district for them to elect their candidate of choice? Whereas, if you had a Democratic primary, can you count on some white crossover voting in the general election for whoever the Democratic candidate would be? So if African Americans can dominate the primary, right, and their preferred candidate advances, well then, will there be some white Democrats and others who would vote for that candidate? That was sort of the issue in the social science in the Kinston case. Bernie Groff and Lisa Hanley and David Loveland have a piece that's right on point with this. Actually, Ellen Capps here also has a piece from a few years ago that looks at all the issues dealing with blanket primaries and party rights, and also the racial vote dilution. And it's it's an interesting area, and the courts have been reluctant to get into it. I have to say the Supreme Court has been reluctant to get into that, because once you start going down that road, then they get really worried about the merging of race and party.
We have time for one last question.
I'm Mike Ballard, practice law from Oakland. I'd like to hear a comment on how reapportionment commissions have performed in the two different contexts. One, the sort of citizens reapportionment, like the one we have in California this round, that have been created by legislation or popular votes through the political process, compared to other reapportionment commissions or referees that have been appointed by courts in the past as part of a judicial redistricting process, both ostensibly for the same purpose of doing a political, neutral reapportionment process, but with very different reporting structures and authority mixes.
Well, I've now worked, I think, 4 courts. I'm currently the special master in drawing the congressional districts in Connecticut, but I'm under a gag order, so I'm not talking about that. But I've drawn in New York, Maryland, and Georgia, and then also advised the commission in Puerto Rico, and then also do the districts in Prince George's County, Maryland, recently. It's interesting there. I worked with the commission for months and months and months, and then they worked with the city council that then drew their own plan. So Bernie Groffman has a piece that compares commissions and courts and legislatures. I mean, the courts get involved on a really expedited time frame, so they can't do what a commission does. So Angelo Ancheta is here. The amount of time, and Carmen Bell, I saw walking into the room who worked with the commission, just the amount of time that they spent in California gathering testimony. I mean, they each should get PhDs if they didn't have them already for what they had to put together for this. And so the level of involvement. Now, when I've done hearings for the court, you probably have one hearing, maybe 2. One where you gather testimony, and another where you will after your plan. But for a state like New York, or congressional district, to have just one hearing is really kind of a needed process, even though it brings out really interesting people and can be very fun. But the court is trying to get a plan done in time for the election, whereas the commissions tend to really be trying to gather information that'll make for a rational plan according to the criteria that adopted. And we should say the obvious, which is not all commissions are created equal, and there are places like Arizona and California, Citizen Commission here, and then you have commissions that are basically the outgrowths of the political parties. You have commissions that are the only person you care about is the tiebreaker appointed by the state, say Chief Justice or something like that. And my view, based on what's happened this cycle and comparing it to the last, is that I was impressed and surprised by the success of the California system. I don't know whether, now that we've had it, whether it's going to be as successful the next time around, and maybe that's part of the lesson of what happened in Arizona, which is that once partisans see how the system works, they figure out ways to get more involved. But at a minimum, you can say these commissions are at least one step removed from the legislature. And so that has its benefits and costs.
Well, thank you all very much. We'll take a very brief break now, 5 minutes, and come back with the second panel, which is going to be on changing demographics in urban communities. Thank you.